Time for further legal clarification on the Emirate Tussle in Kano State. Earlier on, I spoke with legal practitioner Evan Tufeli, and I began by asking him which legal authority has the finance say between the Federal High Court and the state government in matters involving traditional institutions in Nigeria.
According to Section 46, subsection 1 of the 1999 Constitution, which says that if anyone feels that his right has been, is being, and likely to be breached, that person can approach the High Court. Now, the High Court in that context is the State High Court or the Federal High Court in terms of fundamental rights enforcement matters. Okay? So he went to enforce his fundamental rights. So that's why he went to the Federal High Court. How be it that the subject matter is on traditional stool and kingship? I don't know that you understand this. On the scale of things, ordinarily, traditional stool, kingship, and the headship of communities, the state high court have jurisdiction. But in the case of Kano, the man who was aggrieved went to court to enforce his fundamental rights. Under the law, Section 46 of the 1999 Constitution says if your right has been, is being, or likely to be breached, you have a right to approach the High Court. The High Court in this state, in terms of fundamental right, means the State High Court or the Federal High Court.
All right, so Mr. Evans, what are the potential legal consequences for Kano State government if it proceeds with actions that contradict the Federal High Court's ruling?
Yeah, the consequences is where we are already. You know, when the current governor of Kano State reappointed Sanusi, okay, and that party went to court, the guy obtained an interim injunction restraining the government of Kano State from implementing the new Emirate laws of Kano State and for implementing the appointment of Sanusi. The court did not stop the appointment. The court did not stop the law at that time. But the court said that because there's a restraining order, because there's a motion already, and somebody has obtained a restraining order, hold on, don't implement, don't execute. You have appointed, fine, but Sanusi should not start execution. It should not resume office. That's what it means. It should not begin to administer. It should not begin to, there should not even be any form of coronation or whatsoever. But the state jumped that and coronated Sanusi. Sanusi resumed office and Bayero was deposed. Okay, Ado Bayero was deposed in that sense. So the court now had to rule on the substantive suit, the judgment yesterday, and said that because the state government disobeyed the order of the court based on that interim order issued before now, the court have now upon and declare as invalid the appointment, the implementation, and the law itself, and ask parties to maintain the status quo.
All right, lastly, before I let you go now, in cases of conflicting rulings, just like this one between the state and the federal courts, what is the process for determining which ruling takes precedence?
Where you have two rulings on the same issue, the same subject matter, it is an anomaly. It's abnormal for you to have that. It happens in our jurisdiction because sometimes when a case has been filed in a particular court and is being determined, some other persons go to another court to file another case that this court is not even aware of the other one. And this gives another, and sometimes the peculiarities of the case also and the angle through which the parties bring the case to the court also play a role. Sometimes you get a contradiction, okay? But now the Federal High Court and the courts in Nigeria have made it clear that when parties file suit, they must file what we call another document that will evidence that they have not filed the case somewhere else.